Good morning, good afternoon, or good evening, whenever you are watching this. Today I am discussing a quote from Andrea Cancelli and applying it to the UK holiday industry. Consumer protection law exists for a reason. Businesses must observe the law or face the possibility of enforcement action. A quick note about this video that references will be included in subtitles with the bibliography provided at the end. Firstly, consumer protection law. We as consumers have rights. The laws in place strongly protect consumers, and I will discuss the basic legal obligations of consumer law and the consequences faced when not following the law. So consumer rights broadly protect us from unfair issues related to credit and store cards, faulty goods, counterfeit goods, poor service, contracts, builders, and rogue traders. Some of the important legislation that we'll talk about today are the Consumer Protection Act of 1987, the Consumer Rights Act of 2015, the General Product and Safety Regulations of 2005, and the Sale of Goods Act from 1979. A simple one to start the discussion with is protection from crime, just to get this out of the way. This includes the aforementioned issues related to rogue traders and counterfeit goods. Crime or illegality is a mitigating factor in contract law. The contract is flawed from the beginning. Innocent consumers are strongly protected in this, as all contracts dealing with illegality are void. When a consumer falls victim to things like counterfeit goods or rogue traders, they are both void under illegality, or perhaps even misrepresentation in the case of counterfeit goods. I won't dive into the specifics of the regulations, but some regulations dealing with illegality are Consumer Protection from Unfair Trading Regulations 2008 and 2014, Fraud Act of 2006, the Data Protection Act, the Misuse of Computer Act, the Enterprise Act of 2002, which actually does include some consumer measures, and the General Product Safety Regulations of 2005. Generally, the consequences to illegality are contractually. There was never a valid contract created, and the consumer, assuming they're the innocent party, of course, can quantum merit, recover their money, and if applicable, their property. It is also worth noting that courts won't favor guilty parties anyway, so as an innocent consumer, strongly protected. Now to dwell into the legislation. The first one I will talk about is the Consumer Rights Act of 2015. This was a big one as it affected 8 existing legislation. The Sales of Goods Act of 1979 and the Unfair Contract Terms Act of 1977 only applied to business and consumer to consumer contracts after this. And the sale and supply of goods to consumer regulations and the unfair terms and consumer contracts regulations were completely replaced by it. So no business can exclude the Consumer Rights Act of 2015. It is automatically built into every business to consumer. It covers the standards of goods, services, and digital content and the fairness of contract terms. So for standards of goods and digital content, they must be of satisfactory quality, fit for their purpose, and match their descriptions. Should this not be the case, the remedies for these are 30 days to reject and get a full refund, a choice of repair or replacement after 30 days, or if after one repair or replacement is still not up to standard, there will be a price reduction or final rejection refund. Important to note that there is no claim after 6 years from the breach, and other things to note are that businesses cannot force consumers to accept a credit note. There may be a cost of returning faulty goods. Example, if you need to send it back through the mail. Consumers may have to prove there was a defect from delivery, and for digital content, the trader must have the right to supply. For services, the standard must be of satisfactory quality, the service must be of reasonable time and price if not previously agreed upon, and the information given to consumers is binding if the consumer relies on that information. When these standards aren't satisfied, there are remedies. First, Tier 1 is to do it again properly. The consumer does not have an automatic right to use a different trader, and the trader has no automatic right to do it again if the first attempt was so incredibly poor. So it is dependent on the specific case and severity. Otherwise, if not practical, a price reduction up to 100% can be redeemed. Moving to fairness of terms. Broadly, any term is unfair if it is contrary to good faith and causes a significant imbalance in parties' rights and obligations under the contract, and is of detriment to the consumer. Fairness isn't that clear cut and is assessed by the court. Regarding some fairness terms, though, the exclusion or restriction of liability for death or injury resulting from negligence is always unfair. Disproportionately high charges where the consumer decides not to conclude or perform, or terms that allow the trader to determine the characteristics of the subject after the contract is formed, or terms that allow the trader to determine the price after the formation are likely to be unfair. Moving on, I will briefly discuss three more legislation, starting with the Consumer Protection Act of 1987. Consumers are automatically compensated for personal injury, death, property loss, or damage caused wholly or partly by defective product, with no exclusion clause regarding death or personal injury valid, just as the 2015 one. The consumer can sue the producer, own brander, the importer, or simply the supplier unless they tell you who the others are. The next one is the General Product Safety Regulations of 2005, essentially stating that no producer shall place a product on the market, offer or agree to place it on the market, expose or possess it for supply it, unless the product is a safe product. Finally, the aforementioned Sale of Goods Act of 1979, still applicable to consumer, and as the discussed quote does imply business to consumer, I won't go into detail, but in brief, it defines implied terms for the contract of sale regarding when ownership passes, the standard of goods, notes on delivery, and of course, there are remedies for the buyer and seller. So, I won't explain in detail the entire consumer protection framework, as that would take forever. But consumer protection law exists, and it very strongly protects consumers. Businesses must heed to these consumer rights if they want to avoid lawsuits or other legal punishment. That said, we move on to the part where we get to discuss cases, the fun part. So, I have decided to talk about the UK holiday industry. I have some cases that I brought with me, 5 in particular. We'll start with Hollington v. Southern Ferries. This case was in 1977. So Miss Hollingworth's friend received a brochure from a ferry company stating conditions of carriage were printed inside ticket covers. Her friend bought the tickets a few weeks later. The conditions of carriage included an exclusion clause, and during the ferry trip, Miss Hollingworth was injured when her restaurant seat fell over in a storm. So 2 issues here come immediately to mind: the negligence of the ship owners and whether the exclusion clause would hold. Firstly, just to define negligence, it is the breach of an obligation or duty to take reasonable care or exercise reasonable skill. An argument can be made that the boat experienced a storm. It was nature. The ship owners can't control the weather. Out of their control, maybe. On the other hand, though, the ship owners could have looked at weather forecast or instructed guests to be careful or return to their rooms during the storm, or perhaps even nailed chairs to the ground or used chairs with a wider base to prevent falling over. So there's a question of, was it negligence? Secondly, the exclusion clause, it was actually never shown to Miss Hollingworth and therefore was not included in the contract. An exclusion clause must be incorporated into a contract. There was no reasonable notice given before the contract was made. Miss Hollingworth's friend bought the tickets. Miss Hollingworth didn't even see it. Also, remember before, due to the Consumer Rights Act of 2015, businesses cannot exclude or restrict liability for death or personal injury resulting from negligence. So it does seem contingent on negligence. And if you're thinking, but this case was from 1977, that was before the Consumer Rights Act of 2015, then the UCTA of 1977 also states that an exclusion clause cannot be used to exclude or restrict business liability for death or personal injury caused by negligence. At the end, the defendants, Southern Ferries, were found liable for negligence, and the claimant won the case and was awarded damages, compensation. The next case is Chapelton v. Barry, 1940. So, in this case, Chapelton at a resort hired a deck chair from Barry UDC for the beach. A notice stated the cost of hire and advised customers to get tickets and keep them. Chapelton bought tickets and put them in his pocket without looking at them. On one side of the tickets, the council put an exclusion clause for liability for any accidents caused by hiring the chairs. The chair's fabric split away from the frame when the client was sitting on it. The issue here is the exclusion clause and whether it was properly incorporated into the contract. So, as you probably guessed already, the courts ruled with the consumer, Chapelton. The exclusion clause failed because the exclusion clause was on the back of the receipt and a reasonable person would not have noticed it. Additionally, the exclusion clause was only on the receipt, and that was after the contract was made. So a question of timing is also brought in. A similar case dealing with exclusion clauses is Ollie v. Marlborough Court. So I'll only briefly discuss this one. Basically, the claimant booked a hotel room with an exclusion clause for lost or stolen items inside the room. The claimant's items were stolen because the hotel's employees were negligent in looking after the room key. And also there's the same issue here with incorporation. The court ended up ruling in favor of the claimant. The claimant only saw the notice after making the contract, and the exclusion clause didn't specify the loss or damage of property from the hotel's own negligence. The hotel had to pay for damages. Finally, the last two cases deal with disappointing holidays. The first one is Jackson v. Horizon Holidays, 1975. Mr. Jackson booked a holiday through Horizon Holidays for himself and his family, providing details about the family's accommodation, requirements and preferences which had been accepted by Horizon. Mr. Jackson paid around £1,400. And shortly before they left for the holiday, Horizon informed Mr. Jackson the hotel they booked was now unavailable and an alternative that was said to be just as good as the original booking was available for £1,200. The alternative holiday was not as advertised, and the family were disappointed. This brings to question if the Jacksons can recover money paid to Horizon for their disappointment. So this case actually went to the House of Lords. So here the standard of service was not of satisfactory quality, and the consumer relied on the information that Horizon had given them. That it was just as good as the holiday they originally booked. The remedy was not practical to go on another holiday, so the remedy ended up being compensation. Lord Denning allowed recovery, contrary to the usual rule back then, quantifying the damage as £600 for defective performance and £500 for his and his family's disappointment or distress. The final one, Jarvis v. Swan Tours, 1972. Given word limit constraints and the similar nature to the previous case, I will just quickly summarize this one. Mr. Jarvis booked a skiing holiday over Christmas with Swan Tours. The brochure advertised many events that didn't happen or didn't match the descriptions. Mr. Jarvis sued for breach of contract based on his disappointment, and he was awarded damages of £30 on the basis he only received half of what he paid for. So, again, just as the last case, the standard of the service, not of satisfactory quality, and he received compensation. All in all, consumers are the most protected group in any situation, and courts will always favor the consumer. The law will always favor the consumer, especially if there was unfair or unreasonable treatment to the consumer. So businesses could suffer economic and social consequences should they not heed to consumers' rights and treat the consumer fairly. Additionally, perhaps business could even save on legal fees and costs if they simply settle with the consumer in the first place when they know they are treating them unfairly. Finally, to end, another thing to note, an update relevant to current times, the government did issue a statement on coronavirus relating to consumer contracts, cancellation and refunds, which essentially asked everyone to be considerate and nice, or fair to put it in a better way. And that wraps up this video. Thank you for watching and have a wonderful day or evening.